Hello, and welcome to Your Estate Matters with your hosts, my colleague Greg Bichard and myself, Nicole Garten of Heritage Trust.
Your Estate Matters is a podcast dedicated to everything estates, including building and preserving your legacy.
If it's estate related, we'll be talking about it. We're having the conversations today that will help Canadians protect their families, their assets, and their legacies tomorrow. Jeffrey, thank you so much for being with us today and sharing all your expertise and knowledge.
Thank you. Thanks for having me.
So tell us, what is an executor and what are their main duties?
An executor is a person who is appointed under a will in order to administer an estate. And so usually when we're talking about an executor, we're contrasting it to an administrator, which is a person who is appointed to administer an estate where there is no will. So in the case where you have a will and you have an executor who's been appointed by it, they have authority that comes from the will itself, right from the moment of death. And it's not till the moment of death that they have authority to do anything, but right from the moment of death, they have authority to deal with the affairs of the deceased person. So their duties that they take on if they take on this executorship role are to do things like figure out what is the last will of the deceased. So I mentioned they are appointed under a will, but it is possible that the deceased may have a later will-like document, or it's even possible that there may be multiple documents that are forming the will. So, for example, people can, in the common case, people do things called codicils to wills, where they will do in a document that is amending or updating terms of the will. If you have a codicil, it's read together with the original will, and they both form the estate document. But it could be broader than that. BC has legislation, for example, that allows the courts to treat documents that meet what they call the fixed and final testamentary intentions of a deceased person. That is, they are the intentions of the deceased person on how to transmit assets or deal with their estate on their death, to be a will, even though those don't meet the formalities of a will. So it could be, for example, that there are notes that are outstanding out there that say, I want to give my grandfather clock to so-and-so, or I want to give $5,000 to the SPCA, or whatever it might be. And those notes might be something that's also part of the will, potentially. So the executor's jobs, one of their jobs is to figure out what is the will and what are all the components of the will, which could be in multiple documents. Once they've figured out that, they also have the obligation to figure out what the assets and the liabilities of the deceased person are. So they're making an investigation with any financial institutions that the deceased person dealt with, into any real property that the deceased might have owned, doing investigations with the deceased held a company, whether they had an operating business or if they had a holding company, into what shares the deceased owned and what the share rights were associated with those businesses and any shareholders agreements. Doing those investigations to figure out what is it that is in the estate. And that is important because ultimately, at the end of the day, the executor is going to be accountable to the beneficiaries of the estate, and I'll come back to that, for the assets that the executor has located and gathered in to be dealt with as part of the administration. So first identify the will, then also identify, okay, what are the assets in the estate that we're talking about? The other thing that they're going to need to figure out is what are the liabilities in the estate. So not just what did the deceased own, but what did they owe? So if there are any outstanding, say, credit card debts or mortgages would be a common example, or it could be broader than that. Let's say there were IOUs that happened between families, if there was gifts and loans between them, or if the deceased again had a company but owed a debt to the company in the form of a loan that the company had made to them, then they would that would be an asset of the estate that would have to be dealt with. Could be that there's outstanding claims. Let's say, for example, that the deceased was involved in a lawsuit. That might be an outstanding claim of the deceased. Imagine, for example, too, that not just sort of liability claims, but let's say the deceased had separated from their spouse before death and they had not yet resolved as to how assets were going to be divvied up. That's also something that the executor is going to have an eye to when they're figuring out, okay, what's inside, what's outside of this estate, and what are the debts and the liabilities that are there. Taxes are the other thing that they're going to have to think about in the liabilities context. The executor is going to have an obligation to be paying off the taxes of the deceased person and the estate. So The deceased, up until the moment of their death, is an individual taxpayer, and the executor is going to be responsible for ensuring that any tax returns that the deceased was late on filing and had not yet been filed have been dealt with, but also for the year of death, making sure that an income tax return is filed for the year of death, which would be from January 1 up until the date of the deceased's death. So they're dealing with those taxes. The estate also becomes a separate taxpayer after the deceased passes away. And so the estate will have a tax return that's going to be due 90 days after its year end, and there's complex rules as to what the fiscal year end of the estate can be, which I won't get into. But essentially, the executor is going to need to ensure that if the estate is earning income while it's in existence, that they are also reporting that income and on the tax returns and filing those tax returns for the estate. So we talked about will documents, assets, liabilities including taxes. The other major thing that the executor is going to need to do is to gather in the assets of the estate. And in many cases, that will require probate, which I think we'll talk about a little bit later in this program. But to gather in the assets of the estate so that they are able to ensure that they are brought into the name of the executor and securely managed and invested and insured and protected until the executor is able to distribute them to the beneficiaries. The executor needs to ensure that they're reasonably and prudently investing those assets for the beneficiaries until it is time to distribute them. The executor, for example, if they've allowed assets that are imprudently invested to stay imprudently invested, or they themselves take on imprudent investments on behalf of the estate and cause the estate a loss, they may be liable to the people who are ultimately receiving those assets from the estate at the end of the day. So that becomes an obligation. And then while in the meantime, they've figured out what the will is, they figured out what the assets are, they've figured out what the liabilities are, they've started to pay those off, they've paid off some of the debts, they've paid off some of the taxes, they are investing the funds in the meantime. When it comes time to look to distribute the estate, they are also going to be in a position where they have to account to the beneficiaries for what they've done. So they're going to need to be able to show, this is exactly what we started with. Here is every bit of income that we earned since we started administering this estate, since the date of the death. Here's every expense that went out, and here's all the receipts for those expenses so that the beneficiaries can see that the executor wasn't being unreasonable, didn't go and buy themselves a Maserati, or didn't go and rack up a bunch of expenses unnecessarily on behalf of the estate. And provide those accounts to the beneficiaries so that they're able to review them, confirm that the estate was appropriately administered, and if the beneficiaries don't agree to those, bring them to the court and have the court review them and see if they was appropriately administered. And after that accounting process has been done, whether because the accounts have been approved by the beneficiaries or the court, ultimately distribute the estate. So that's sort of the beginning to end look of what the estate administration process looks like and what the obligations are for the executor. I will say, though, that there's more duties still yet that fit in there, because those are the things that the executor has to do, but in terms of how they do them, that's also informed by law. So one of the main obligations of the executor will be to review the will, and they should be doing that with counsel and getting legal advice to do that, to confirm what it is it's telling them to do and make sure that they are ensuring that the beneficiaries are getting what they're entitled to under the will, and that they are distributing the will in accordance with its terms and administering the estate in accordance with its terms. But also when they're doing that, there's certain duties that they have, which sometimes are referred to as substratum duties. There's sort of these underlying should duties that are telling them, informing the executor as to how they behave. And those are things like ensuring that they are meaning what they call their duty of care, so that they're using reasonable care and skill when they're administering the estate. So they're administering the estate in the same way, objectively, that a prudent person would be administering the estate on behalf of another person. They also need to be acting impartially among the beneficiaries. And that doesn't mean that they're treating all the beneficiaries equally. It's not that they get the same amounts from the will, for example. But impartiality means that the executor is ensuring that the beneficiaries are getting no more and no less than they're entitled to under the will at the end of the day. So no preferences in terms of deciding, you know, I want to be administering this estate in a way that is going to give greater benefit to this beneficiary versus that beneficiary. They have to be making sure that, unless the will is telling them to do otherwise, that they're treating everybody fairly. They also have a duty of loyalty. The duty of loyalty means that the executor needs to ensure that they are acting only in the best interest of the beneficiaries, not themselves. So they can't put themselves in a conflict of interest with the estate. So, for example, unless the will says otherwise, the will can modify this. But let's say, for example, there's an estate, it's mom and dad have passed away, it's mom's estate. The main asset in the estate is a home. There's 3 siblings who are receiving it. One of them's administering the estate. And they're receiving it in equal shares. The one who's administering the estate couldn't decide, I want to go and buy this home for $1 from the estate, and then appropriate themselves an asset from the estate essentially and leave not very much to be distributed amongst the other beneficiaries. They need to make sure they're not stepping into those conflicts and that they're acting for the benefit of everyone as a whole. Broadly speaking, those are the duties. There's a few others. They need to not delegate. They have to act personally when they're administering an estate. And they also have duties to provide information. So I mentioned the records and accounts that they have to keep. In addition, if the beneficiaries are asking for information about what the will is and what the terms are of the will, generally speaking, the executor is required to provide that information. There's some case law that qualifies what that duty looks like, and it's very fact specific in terms of what a court will require an executor to disclose to a beneficiary when information requests are there. So there's some nuance there, but typically speaking, they have to be providing information to the beneficiaries.
So that's an amazing overview, Jeff. Thank you so much.
You're welcome.
What about the deceased body?
In terms of how to deal with it. So as a first priority, it falls to the executor to be the person to make the funeral arrangements and to be dealing with the interment of the remains. If a will hasn't been located, and typically, the body is going to be dealt with usually within a week or so of death, it's possible that the will may not have yet been found. It's also possible that people may not have started making an inquiry into finding the will. Typically what will happen in those situations is that the funeral home will be speaking with the next of kin and they will be making those arrangements. But the legal authority to do so is actually with the executor if there is a will in place.
Now, have you found that in your practice, most people do not describe what they want done for their funeral in their will?
It's a real mix, to be honest.
Yes.
And you know what, actually I find is quite common among many clients is I often find people say, I don't want a service. I don't want a funeral. I want this to be as simple as possible. Don't waste the money. But it really depends on the client. And I like to spend a little time chatting with them about what the options are and what their interests are, because for some people, it may be very important to have a service done in accordance with certain rites. It may be very important to have cremation versus a burial. There may be thoughts about where they want their body placed, which can be an interesting one because sometimes it may be, I want my remains to go back to the old country or wherever it might be. Sometimes it may be I want it next to my spouse. Sometimes it may be I don't want it next to my spouse. And so you have to figure out what this particular client wants and work with them in that regard there.
What are some funny funeral instructions you've seen?
Funny funeral instructions that I've seen? I'm not sure that I've seen many funny funeral instructions. I have certainly seen ones that were more contentious in terms of we're talking about where the remains are going to go and it's not necessarily what the family wants. And those are the situations where people are not going to be silent, where there's something that there's really important to them and where they think that their wishes may not be met by the executor or the next of kin. That's when they're going to really be clear about what they want at the end of the day.
And if not otherwise described as an executor duty, when, say, friends or family approach the executor and say, well, we want to have a celebration of life and we want $50,000 or $20,000, should it really have been described in the will that there would be money allotted, or what would be the practice
to do that? So, if you look at the case law, what it will say is that the funeral expenses have to be reasonable in the context of the estate. And so if they don't have a lot of assets and someone is saying, we want to be spending a lot of money on the funeral, the executor is going to be in a conflict there and saying, well, we can't really do that. We need to be keeping this as trim as we possibly can. So In a larger estate, though, if it's a larger affair that they want, it may be totally appropriate in the context of the estate. The executor is going to have to make that judgment. So if they know that if the deceased person knows when they're doing their planning that they're going to want a large or elaborate funeral arrangements, and they really want to make sure that that happens, I agree with you. They should be allocating in the estate because it's going to make the executor's job easier to show that that was appropriate. The other thing that they can be doing, and that I often have clients go and look at, is going and talking to different funeral homes and figuring out their arrangements for their funeral expenses, for their funerals in advance, so that they're able to have a little bit more control as to what it would look like, and you can prepay a lot of your funeral expenses in most cases. So. But there's lots of options out there for people. You know, there's mushroom suits now, or you can be turned into a diamond, or you can be shot into space. I know there's a few death doulas who operate in the greater Vancouver area. So if you want to go and consult with somebody about different options for you, there's lots of things you can go do.
Jeff, now when an executor is up and running and or somebody's doing the planning, the question that always comes in, what is the typical executor fee in BC?
You know, I'm going to caveat this by saying that when you're administering an estate, it can take a long time. You often will have the beneficiaries rattling at the gates and saying, we want this right away. Oftentimes it takes a few years to get an estate fully administered from start to finish. And you may not know how complex it is until you start digging into the weeds and figuring out the person's affairs. And so the typical executor's fees, our system in BC by default actually allows a scale that allows the fees to respond to the complexity of the work that was involved. So by default, if your will says nothing about executor's fees, we have a provision in what we call our Trustee Act that sets out what the remuneration of an executor is. I think it's Section 88, but of that act, it says that the executor is, for administering an estate, able to take a fee that's up to 5% of the income and the capital of the estate, plus if there's ongoing trust created under the will, so that the administration is going to take further years still. We're not just doing outright gifts. We might be holding funds in trust for minors or for a spouse or whatever it might be. There's a up to 0.4% what they call care and management fee. That's an annual fee that they can take for administering those funds. I say up to because your question is what's the typical fee. The court, if the executor is going to take those fees, the executor is going to propose to the beneficiary what they think is fair in those ranges. And if the beneficiaries disagree with what the executor is proposing, the executor is going to get it reviewed by the court. And if a court is looking at it, they're going to look at a number of factors. They're going to say, how big was this estate? How involved was the administration in the sense of how much time did this take for the executor to actually administer it? Was there any unusual complexity in the administration of the estate? Was there any special care or skill that the executor needed to apply to the administration? And how successful was the outcome? So you can imagine, for example, that in your typical estate, if we just have a piece of real property and we have a few bank accounts, typically what I see in those cases is the fee would be somewhere in the range of usually it's about a 2.5% to 3% capital and income fee, usually. Again, it can range. But if you have a more complicated estate, let's say you have businesses that need to be administered or wound up, or let's say that you have assets in multiple jurisdictions, which is actually fairly common now for a lot of people, that you might not just have things in BC, you might also have, say, real estate in the US, or you may have bank accounts in the UK or whatever it might be. That's going to add to the complexity of the administration and it's going to increase the fee. Outside of those fee ranges, though, the will maker is able to provide in their will what they want for their executor to be taking from remuneration. It's very rare that they can say that they get nothing. It's very rare that they do that. And I tend to push clients away from doing that, just in part because the estate can be quite complicated and it's sort of a thankless job that the person is doing. And so you want them usually to be able to take compensation if it's appropriate in the circumstances. But the client is able to specify what they think is a fair rate. They might say that, I want them to be able to take this percentage up to this amount. They might decide that I want them to take a flat fee. Sometimes we'll do that for tax reasons too. The executor's fees that they receive are taxable as income, but any amount you get as a gift under a will is not actually taxable in your hands when you receive it. So if you have an executor who you also want to benefit as a beneficiary, and you sort of want to compensate them for what they're doing, but you may not want it to be so tax disadvantageous, you might structure it so it's a gift rather than a fee under the will. Another thing you might do is hourly rates. And that's quite common if you have professionals involved. So let's say if you're getting your lawyer or your accountant because they're familiar with your affairs to be the person who's the executor under your will, you might say that they're entitled to be charging their usual professional rates, which is typically hourly fees, to be acting as an executor. So there's a range there.
So it sounds like an enormous amount of work and potentially a lot of complexity.
I've never heard anyone say that was easier than I thought it was going to be.
Yes. And potentially risk if mistakes are made.
Yes.
And so thinking about this serious responsibility, how does someone go about choosing an appropriate executor?
That is something that is really a critical part of the estate planning process. And I think there's a few things that go into it. So one, you need to look at what the will's doing first. So, in the context of talking to the client, if I'm meeting with a client and working on an estate plan, we're thinking about, okay, what is the structure of this will going to look like? And there'll be different things that are motivating that. You might have a beneficiary who has a disability, for example, and we're thinking we're going to need ongoing trusts. You might have a situation where there are larger companies that need to be dealt with. And we're thinking, okay, we're looking at different structures to ensure that we can be reducing taxes that are potentially payable and to also make sure that we are streamlining those administration of those companies after the person passes away. And so looking at how complex the will is and what it's asking you to do, that's partly going to inform your executor decision. If it's a will that's giving all to my spouse outright and your spouse is fully capable and you think that, they'd be up to the task, you're probably going to say, let's just appoint the spouse as the executor. That makes great sense. If you're looking at a will, though, that has ongoing trust, for example, as I mentioned in it, you're going to be thinking about, okay, who is going to be appropriate as the person around me to step in that role and actually administer that trust long term? Who's going to be around long enough? So age is something that we start to look at. Who is going to have the financial sort of acumen to be administering this estate or the trust under it. So if it's going to be a longer administration, and if we are going to be needing to invest, say, significant funds, or if we are going to be administering businesses, who is going to be the appropriate person to actually have the skill set to do that, or would be the type of person who would know how to engage other people who could assist them when doing that. So getting assistance from other trust companies or accountants or lawyers or whoever it might be. So those are some factors we're looking at, is the skill, and we're judging that based on the way that the will is structured. We're also looking at age, frankly, if there are going to be longer term trusts, particularly in the administration of the estate. It might decide that, this person's still appropriate as executor, but not the trustees under the will. But that's, again, something we're looking at. Willingness to do it is obviously a big one. You can appoint the person who you think would be great, but if they don't have the time and they don't want to do it, they're not going to be the appropriate person to appoint. And if you may also decide that, it's appropriate to appoint multiple executors. Maybe, again, you have an estate that's going to your kids and you think, I want them all to work together. I think they'd act as good checks and balances on each other. And I think it's appropriate for them all to step into that role together. It might be appropriate to have all of them act together. If you're doing that, though, you're going to have to be thinking very carefully about dynamics. And that's another piece that sort of floats in the background in terms of who's the appropriate executor, is who gets along with the beneficiaries. And if we have multiple decision makers, are they going to get along with each other? And I often see wills where people have that come to me in the estate administration context, and people have appointed, say, all the siblings together, and they loathe each other and they can't work together, and you just end up getting into deadlocks and stalemates, and it's very difficult to deal with that on the estate administration side. And the worst case scenario, you're bringing court applications to try to remove somebody at the end of the day. So those dynamics are important. Tax reasons are also a consideration. So an estate's considered to be resident for tax purposes where its decisions are being made, essentially. That's what it boils down to. And so let's say, for example, you have a friend or a family member in the US who you think that's the person that I want to be administering my estate. one consequence of doing that is it may make the estate resident in the U.S. for tax purposes. And that can have certain consequences, which I won't go into now, for both Canadian tax purposes and also in the other jurisdictions' tax purposes. It will be pulled into that other jurisdiction's regime, and there may be additional reporting or filings that's there. So sometimes, in those cases, if we are seeing that there's someone who is not resident here, that might be appropriate. We might also be looking at doing multiple executors on the idea that we can have someone also resident here and try to tie the decision-making more towards Canada, and in that way ensuring that we're keeping the estate Canadian tax resident and avoiding some of those errors. So lots of factors that float in there.
What is the actual probate or the probate process, and does every estate need it?
The short answer to that is no. And actually, we do a lot of planning to try to avoid it where we can. But the process for probating a will, and I'll start with what it does. So what a grant of probate is it's the court giving its approval that a will of a person is their last will. And that is important because for third parties in particular, so let's say you're dealing with a bank, for example, or you're dealing with, say, the Land Title Office, they don't want to be liable for acting on a document that they don't know is a will. As I mentioned, you could have many will documents out there. And it's also possible that the document that you have and you think it's a will is not the last will of the deceased person. And the issue for, let's say, a bank is that they don't want to give away the assets in the deceased account to a person who's showing up and saying, I'm the executor of this will, unless they know that is the will and it's the last will of this person. And so what the effect of the grant of probate is there's sections in our legislation that say that a person who is releasing assets or information on the strength of a document, on the strength of a will that has been probated, where there's been a court order approving that as their last will, is not going to be liable for having acted on the basis of that document. So it allows persons to deal with the assets in that case. And for purposes of dealing with land in BC, if it's in the deceased name solely, our legislation under our Land Title Act says you can't deal with it unless you get a grant of probate. So it's proof to these people that this is a will that's been approved by the court. There's two types of probate, and they are important to distinguish because they do slightly different things. One is called proof in common form. One's called proof in solemn form. Proof in common form is just as it sounds. It's the one we commonly do. And we commonly do it because it is the cheaper and faster way to go. What it essentially is that there are materials that are going to be filed with the court. So you're going to be filing the original will. You're going to be filing results of a search of a wills notice. It's possible to register a notice saying that I've made a will and here's where it's located with the Vital Statistics Office. So there's a copy of that registration that's filed that shows that there's no later will than the one you're submitting to the court. And affidavits, which are sworn written statements of the executor they're made under oath and they're signed before a lawyer or a notary. And they will essentially describe that the executor has made a diligent search, hasn't found any other document that looks like a will, is filing the wills notices, is filing the will. And there's also an affidavit that they'll be filing that sets out all the assets in the estate. And those assets are used for purposes of calculating what are called probate fees in BC, which is a tax of 1.4% of the value of the assets that are flowing through the estate. So those materials are filed with the court. Once the materials have been reviewed by the court then requests its probate fees, and then when the probate fees are paid, the grant of probate issues, and the executor can though start dealing with the accounts, etc. That's the common form procedure. The solemn form procedure looks more like a trial. And it's a longer and more involved procedure because you're giving evidence in person to the court rather than through these written affidavits. And the reason for the differences in the procedures is the common form procedure is just approving this as the last will of the deceased person, but it is not specifically deciding that the will is valid. And to be valid, a will has to be made by a person who is mentally competent when they were making it. who understood what they were making at the time. They understood the contents of the will, and that no one was forcing them to make their will that way. You can be perfectly competent, but if someone's holding a gun to your head, it's not your will at the end of the day. So the solemn form procedure is improving those elements so that if there is any question about the competency of the person who's making the will, or any question that they were acting freely, those questions are being determined in the course of that application. So in other words, what is it for? It's so that you can start dealing with some of the assets in the estate. And how do you get it? There's these two procedures. They do different things. There's different costs to them, but they're necessary in order to do those initial steps. There may be some other reasons, though, that you get probate. You may not have really any asset that you need to get probate to deal with it. Let's say, for example, if you have a holding company or an operating company and it's your private company, typically you don't need probate to deal with that asset because there's not going to be a third party saying, I'm not going to allow you to deal with the shares of this company unless you get probate. So you can deal with it without probate, but you may have a situation where you have a spouse or a child of a deceased person saying, I don't think the will makes fair provision for me. If that's the case, they're able to bring a claim to try to change what the terms of the will says, so they get a greater benefit under it. The time period in which they can bring that claim doesn't start ticking until a grant of probate has issued. So you may need probate just to start that will's variation limitation period, what we refer to it as. Or again, there may be questions about was this will valid? So you may need probate for that reason. It's not to deal with the asset, it's not to deal with will's variation, but it's because someone thinking that the will maker was not capable or was being forced to make the will. It may also be that you might just have an intransigent beneficiary saying, we're not going to agree to have this estate distributed unless we get proof that this is the last will of the deceased person. In that case, you're also going to need probate. So that's the probate process.
What happens if somebody dies without a will?
When you die, and I'm going to contrast it to when you die with a will. When you die with a will, all of your assets vest in the executor as of the moment of death. They can start dealing with your estate. They may need to get probate to access certain assets, but otherwise they're good to go. When you die without a will, there's nobody who has automatic authority to deal with the estate. All the assets of the estate are technically vested in the court, and it's not until someone has applied to the court to be appointed to administer the estate that there's anybody who can start dealing with the assets or dealing with the deceased's affairs. That also means that there's no one who's available to do things like file tax returns on behalf of the deceased. So if you die without a will, you're going to be looking to bring an application to appoint someone so they can start administering the deceased's affairs. The court order in that case is the thing that is giving the person authority to deal with the estate. Whereas in the case where we had an executor, it's the will that's giving authority for the person to deal with the estate. So it's not until you get the court order that you're able to start them managing the estate. And what we have in BC is essentially a legislated will that talks about where the assets are going to go after the estate has been administered. And what that says is that it's essentially to the next of kin. So there's rules about if you have a spouse but no kids, it goes to the spouse. If you have a spouse with kids, there's rules about a certain amount of the share that the spouse first gets and the remainder being distributed between the spouse and the kids. If you don't have that, later descendants. And then if you still can't go down the line, we start looking up and down your family tree. So we look for parents. If you don't have parents, we look for siblings. If you don't have siblings, if you don't have those, we have nieces and nephews, etc. And we keep sort of going up and down the tree. If we reach no one down your parents' lines, we go up to your grandparents' lines, etc., up to 5 degrees of separation from you. If there's nobody who we hit, ultimately what ends up happening is that the estate is going to do what's called an escheat, where it's going to be paid over to the government at the end of the day. And the persons who can go and be appointed to administer an estate, broadly speaking, roughly mirror the people who are going to be taking under the intestacy rules. So the spouse has the first priority to apply to administer the estate. If the spouse doesn't apply, a person nominated by the spouse can apply. The next is the children who can apply, and the next a person nominated by a majority of the children. If they don't agree, one of the kids who doesn't have consent of the other kids can apply, and then the rules continue to go down that way to the intestate successors who have the priority to apply to administer it.
You've been an incredible resource of very deep and detailed information.
Oh, yeah, thank you.
If people want to find out more, do you have ideas of where they can look?
If you go to your local library, there are books and guides on estate administration and the probate process in BC. I think actually Heritage Trust has one. I saw in the Vancouver Library. You have a boot camp book, don't you?
Yes.
There are resources that are online. The Courthouse Library, which by the way is an amazing resource, and I would highly recommend people go and check them out. So they have branches at some of the various courthouses in BC. There's one at the courthouse at Robson Square downtown, and it's open to the public, so you don't have to be a lawyer to go and access that. And again, the librarians are amazing, very helpful. But they have a number of resources there. They have a website that they administer called clicklaw.bc.ca. And ClickLaw has actually a compilation of various guides and materials on the estate administration process. So it's a good place to go and look to find that information. The province of BC on their website also has some information about how to complete the application forms for a grant of administration or for probate. There is a manual out there published by the Continuing Legal Education Society of BC called the Probate and Estate Administration Practice Manual. That's really a guide for practitioners, and it's updated by practitioners. I actually write one of the chapters for it on conflict of laws in estate administration. But it's a really good resource to use. It may be more technical than you need for an overview of the process, but if you need to dig into any issues a bit deeper, it's a good place to start. Also, there's an organization called NIDIS, which is a not-for-profit that is geared towards ensuring that people have done estate planning and that they also have resources for estate administration, and they have resources as well. So those are good places to start. I would, though, strongly recommend that people do go and talk to counsel if they are administering an estate. And the reason is because while there are these resources out here that are there to act as a guide, you won't necessarily know all the things you're looking for in the estate administration. There are different issues and there's different options that can have different effects for tax purposes, or there may be questions about the interpretation of the will, etc., that you're not going to be able to identify and get assistance with unless you have a lawyer assist you. And so I would strongly recommend that people do engage counsel if you are named under a will or if you're thinking about administering an estate to get that advice. The advice may also include as to whether or not you should be taking on your role as the executor or the administrator, and the liabilities that you will be taking on in the context of the estate. And so it's important to get that protection for yourself first. I'll also note that executors and administrators' reasonable legal fees are chargeable of the estate, not by the executor or the administrator personally. So ultimately, it is an estate expense, and that it is an appropriate one for someone administering an estate to bear.
Amazing, Jeff. You've been such a resource for people. How can our listeners find you?
They can find me online. I think, I've never worked on the SEO of our website because we do most things by referral. So I think I'll show up as number 70. But if you type my name into Google, it's Jeffrey Bichard, Bichard. Our website for our firm, our firm is Scion Law. So it's www.scionlaw.com.
Great. Well, thank you so much, Jeff.
Thank you very much, Jeff.
Thank you.
This podcast is for informational purposes only and should not be considered individual legal, financial, or tax advice. Make sure to consult the advisor of your choice to advise you on your own circumstances. Thank you for joining us for this episode of Your Estate Matters. If you like this podcast, make sure to follow it on your podcast platform of choice.
Whether you are planning your own estate or you're acting as executor for somebody else's, Heritage Trust can help. Partner with Heritage Trust to protect your family, your assets, and your legacy.
If you would like more information about Heritage Trust, please visit our website at heritagetrustcompany.ca.
This podcast is produced by Podfather Creative.